Can you appeal a motion to dismiss? This question often arises when a legal case is dismissed, leaving plaintiffs wondering about their options. Understanding the appeal process and when it's possible can be crucial for those seeking justice in the legal system. A motion to dismiss is a request made by the defendant to have a case thrown out before it goes to trial. When granted, it can feel like the end of the road for plaintiffs. However, the ability to appeal depends on several factors, primarily whether the dismissal was with or without prejudice. A dismissal with prejudice is typically final and prevents the plaintiff from refiling the same claim. This type of dismissal is generally appealable because it represents a final decision on the merits of the case. On the other hand, a dismissal without prejudice allows the plaintiff to correct deficiencies and refile the claim. These dismissals are usually not appealable, as they don't constitute a final judgment. The general principle of appellate practice states that only final decisions or judgments can be appealed. This rule exists to maintain the independence of district judges, prevent abuse of the appeal process, and avoid wasting court resources on matters that may not be significant in the long run. However, exceptions do exist. Some dismissals, such as those involving fundamental constitutional issues or jurisdictional questions, may allow for immediate appellate review. These are known as interlocutory appeals, which can be filed before the final resolution of a case. When considering an appeal, it's essential to establish valid grounds. Common reasons include legal errors, where the court misapplied the law, jurisdictional issues, failure to state a claim, violations of due process, or misinterpretation of procedural rules. Each case is unique, and the specific circumstances will determine whether an appeal is viable. The process of filing an appeal typically begins with determining if the dismissal is indeed appealable. If so, the next step is to file a notice of appeal within a specified time frame, often 30 days from the dismissal order. This is followed by preparing an appellate brief that presents legal arguments and explains why the dismissal should be overturned. In some cases, oral arguments may be required before the appellate court issues its decision. It's worth noting that appealing is not always the best or only option. Alternatives exist, such as filing a motion for reconsideration, amending the complaint if dismissed without prejudice, or even considering alternative dispute resolution methods like mediation or arbitration. In conclusion, while it is possible to appeal a motion to dismiss in certain circumstances, the ability to do so depends on various factors, including the nature of the dismissal and the specific grounds for appeal. Understanding these nuances is crucial for anyone facing a dismissed case. Given the complexity of appellate law, consulting with an experienced attorney can provide valuable guidance and increase the likelihood of a successful appeal if one is warranted.